alleged grievance was only initiated in 2016. Was the claim of the respondent affected by delay and latches as such able to be dismissed? Now, these are the questions which in our considered view, which arose for consideration before this court. And we have answered one by one. We just briefly, we understand this morning and we also have to go to the court, but we'll tell you. We have said that Article 309, we have extensively discussed, and the principles enunciated are non-exhaustive. One. Questions number 2 and 3, we have come to the conclusion that in some it is hereby concluded that DA by its very nature is non-static, fluid, and subject to change. How that change is to be carried out is through the AICPI. The first memorandum is also the subsequent memoranda fall prey to the fatal flaw that they do not make reference to the AICPI, which is absolutely essential to the determination of the DA, which in turn is indispensable to the computation of the total amount of existing emoluments. As a necessary follow-up thereto, it would be observed that the incorporation of the AICPI cannot be termed as a one-time measure, and once DA was defined using it, to take a different path would be impermissible in law. So questions 2, 3, 4 are answered accordingly. Now, insofar as question 5 is concerned, it has got two facets as we read. One is with regard to the arbitrariness on the part of the state, and the second is with the legitimate expectation of the employees. And all these, on both these issues, we have said that keeping in view the judgments referred to above, the principle of manifest arbitrariness under Article 14 refers to legislation that is capricious, irrational, lacking reason principle, or excessive and disproportionate. Such arbitrariness vitiates both subordinate and plenary legislation like. In the present fact, since the legislative exercise did incorporate AICPI into the framework, deviation therefore from without any basis or discussed above falls in the lacking of reason principle prong to manifest arbitrariness passed from legislative competence. For the apparent state to have deviated from the recognized position to something else without laying the groundwork therefore compromises the exercise of rendering it capricious. So that is what we have read. Insofar as manifest arbitrariness is concerned, we have further elaborated, and we have held that it is not so in view of Hakamchand Supra, which you had referred to. And insofar as legitimate expectation is concerned, we have said that, of course, it cannot be unless it is by rule of law. And we are of the view of that in the light of the principles referred to above, the legitimate expectation on the part of the respondents did arise in view of the change in the position of law. Otherwise, there is no legitimate expectation. Enactment of ROPA and its recognition of AICPI as the determining factor for the computation of DA. Now, question number 6 and 7, whether there is any conflict in between the list 1 and list 2 of the schedule. We are of the view that this question does not arise in our considered view at all, and therefore we have said that there is no conflict. These both are coextensive and working in a totally different plane. Then the next question we have said is that the alleged conflict in our considered view is a figment of the imagination of the apparent state. The argument seems to have been conjured up in thin air. Where is the exercise of the power of the union, legislative, and executive imposing any conditions of the apparent state? On the contrary, the power exercised is only by the apparent state through the governor, permissible under the constitutional scheme in terms of Article 309 of the Constitution of India. Now, coming to the effect of the finding of the first round of litigation, we have said that yes, it has conferred a right on the employees. Whether the respondents were entitled to DA twice a year. Here we are in agreement with the submissions made by the appellants that DA cannot be given twice a year. So to this the appeals are allowed. Now, fiscal policy and judicial review. We have elaborately discussed that once there's a right which is conferred upon a person, then fiscal policy cannot be come in the way of the disbursement of such rights. Now, whether dearness allows the fundamental right, we have said that in terms of the impugned, because it was not given up really, in terms of the impugned judgment, the High Court held the payment of DA was a facet of Article 21 of the Constitution of India. Before this court, however, the opposing parties have jointly agreed that none will press this question either way. That being the accepted position, we do not give any finding thereupon and leave the question open to be decided in an appropriate case. So the appeal is allowed to that extent also. Now, whether there is delay in latches, we are of the view that the employees have been relentlessly pursuing the matter before different fora. So, therefore, their legitimate claim, which is recurring in nature, we're giving a fresh cause of action every moment, cannot be said to have been delayed, cannot be denied on account of delay in latches. Now, the directions part we have read is this. Apropos to the above, we pass the following order. The appeals are partly allowed on two issues. To receive dearness allowance, page 128. To receive dearness allowance is a legally enforceable act that has accrued in favor of the respondent employees of the state of West Bengal. Given its incorporation in ROPA rules, the AICPI is the standard to be followed by the appellant state of West Bengal for determining of existing emoluments. The employees of the appellant state shall be entitled to receive the arrears in accordance with this judgment for them from the 2008 till 2019. On 16th of May, we had passed following interim order. We have extracted that interim order where we had said that some amount be immediately dispersed. The interim directions issued are herein shall be complied with immediately. On account of subsequent change in law, if any amount that would be dispersed in compliance with the judgment shall not be liable to be recovered. Considering the financial implications involved and also recognizing the need for structured release of the funds so as to not prejudicially impact state's exchequer, while at the same time balancing the rights of the employees to receive the emoluments due to them, we find it fit to constitute a committee to monitor the implementation of the directions herein above as follows. We have requested Honorable Ms. Justice Indu Malhotra, a former judge of this court. We have also requested Mr. Trilok Singh Chauhan, former Chief Justice of Jharkhand. We have also requested Mr. Gautam Bhaduri, also a judge of retired judge of Chhattisgarh, and along with them, the Comptroller and Auditor General of India, or a senior most officer in his establishment nominated by him. The import of the committee shall be in consultation with the state authority to determine the total amount to be paid, schedule of payments within which the state shall be bound to follow, periodically verify the release of these amounts. The exercise to determine A and B shall be carried out before 6th of March 2026. The next consequential step, that is the payment of first installment, subject to the determination of the committee, would be paid before 31st of March 2016. The committee shall be accorded all facilities and privileges, including all necessary logistical arrangements. Expenses shall be borne by the appellant state. Insofar as the remuneration is for the committee members is concerned, we leave it to the wisdom of the chairperson. It stands clarified that those employees of the state who have retired in dependency of this litigation shall also be entitled to benefits in accordance with law. Let the appellant state, after payment of first installment, file a status report indicating the determination made by the committee, the schedule adopted, the status of the first payment, list on 15 May for compliance. These pending applications also stands.
Great. Very good.
My lords, the employees are extremely grateful.
We'll only say we have rendered justice, that's all. Right or wrong, good or bad, we don't know.
Actually,
chairperson लिखा है ना.
grateful.
Thank you, madam.
Very good.
Very good.